Our distinguished speaker today is a renowned teacher, lawyer, and public servant, and a treasured member of our community for more than 50 years. Walter Dellinger is the Douglas B. Maggs Professor Emeritus of Law at Duke. Professor Dellinger joined the law school's faculty in 1969 and was a resident faculty member at Duke continuously from 1969 to 1993. In 1993, President Bill Clinton nominated Professor Dellinger to serve as Assistant U.S. Attorney General and head the Office of Legal Counsel, the principal legal advisor to the Attorney General and the President of the United States. After being confirmed by the Senate, he held the position for 3 years, issuing opinions on issues ranging from national security and international trade to affirmative action and religion in the public schools. 3 years later, Professor Dellinger was tapped to represent the government before the United States Supreme Court as acting Solicitor General. The 9 cases he argued during the 1996 and 1997 term, the most by any Solicitor General in more than 20 years prior, included matters involving physician-assisted suicide, the line item veto, the Cable Television Act, the Brady Act, the Religious Freedom Restoration Act, and the constitutionality of remedial services for parochial school children. Those of you who are graduating, I challenge you to try to figure out which cases those were. Now a partner in the appellate practice group of O'Melveny and Myers in Washington, Professor Dellinger lends his expertise on the court and constitutional issues to both private and pro bono clients, and through frequent public commentary. In 2013, he was honored with a Lifetime Achievement Award by the American Lawyer, and he has been named one of the most 100 influential lawyers in America by the National Law Journal. Professor Dellinger is a graduate of the Yale Law School, where he was an editor of the Yale Law Journal, and he served as a clerk to Justice Hugo L. Black on the Supreme Court of the United States. We are delighted that he could be here with us today to address the class of 2020. Professor Dellinger.
Thank you so much. It is a wonderful honor. I hope all of the parents and relatives and spouses and partners are as proud of these students as we at Duke Law School are. And what I would like to say to those of you who are graduating into this world of uncertainty is that you have an unparalleled opportunity to help lead us out from a dark period and to think about what fundamental changes need to be made in our way of living, our way of being, and our way of governing. So you are challenged to be part of a special time. And what I want to say to you briefly this evening is that in almost every important respect, you can choose to be the lawyer and the person you want to be. The great qualities of being a lawyer are by and large qualities that you can conscientiously adopt. That is, having good moral values, being conscientious and having a capacity for hard work, having a willingness to support and assist the work of others who are your peers, a respect for the dignity of every single person who works in your institution, no matter what their role may be in the organization, a quality of empathy for those who are unlike yourself. In short, a commitment to being an ethical lawyer and a good person is within your capacity. And in my half century of watching our graduates, I can tell you, but I look at the correlation between how people did on one measure, that is academic grades, and how fulfilled they were as professionals and how rewarded they were as persons, is that there was no correlation. There's no correlation. That you can choose for yourself. Well, let me speak to you about America's greatest lawyer, not because any of us can ever hope to achieve anything like what America's greatest lawyer achieved, but because it conveys a sense that you can take the lawyerly skills that you learned at Duke Law School and will be enhancing in the years ahead, and you can apply them in all kinds of different ways. whether it's on the school board or the town council or in civic organizations or in the practice of law or as public defenders or prosecutors, that's all up to you, but those skills are readily transferable. So think about Lincoln, America's greatest lawyer. On June 16th, 1858, he woke up with every reason to think that he was a failure. He was 50 years old, well regarded in the provincial town of Springfield, population 7,000, not much known outside Illinois. In most respects, his life was going badly. He did not have any financial security. He had a frail and beloved son. His wife, in a difficult marriage, was afflicted with serious emotional problems, as perhaps was he. But most of all, he would have had a sense, in his view, of not having amounted to much in the world on June 16th, 1858. He had had a couple of terms in Congress, but that was about it. He failed to get his party's nomination for the Senate. But what roused him from that depressed slumber of age 50 was the Supreme Court's decision in Dred Scott versus Sanford, which held that no person of color, slave or free, could ever be a citizen of the United States, and that Congress had no power to prohibit slavery in the territories. He roused himself to give a speech that night, which we think of as the House Divided speech. It was poetical, full of biblical references, metaphorical, and yet it was a legal analysis. He became the first person ever to become a national figure on the basis of an analysis of a Supreme Court decision. That led him into the debates of his public life when he set out, I think, always sensing that he wanted to be president, which would have surprised almost everyone else. But he knew, because he had a deep moral commitment. As I would not be a master, I would not be a slave, was the bedrock. But he used the Dred Scott decision to say that we could no longer survive half slave and half free, that we shall lie down pleasantly dreaming that the people of Missouri are on the verge of making their state free, and await to the reality instead that the Supreme Court has made Illinois a slave state. And he committed himself to meet and overthrow the power of that dynasty as the work now before all of us who would prevent its consummation. But what he did was to use, you could take, and I will suggest this to you as a matter of study. Email me and I'll give you further thoughts on this. He used techniques in private law representing banks, debtors, creditors, plaintiffs, and defendants. The techniques he used as a lawyer were the same techniques he used in public life. You can almost match them from private life and public life. And he made a decision not to compromise on principle, but to try to achieve a pragmatic objective. William Lloyd Garrison took a different route. He was the great emancipator, the liberator. He said that the Constitution was a covenant with death, an agreement made in hell, and no right-thinking person should cast a vote under such a regime. Lincoln tried to read the Constitution for the best for which it could be read, and to find a way to deal with the great issues. What was he going to do about the fact that he's running as an emancipation candidate in a state that is solidly against emancipation? That had made it a crime to bring a person of color into the state just a few years earlier. He had the formulation where he would say, either the opponents of slavery will arrest the further spread of it and place it where the public mind shall rest in the belief that it is in the course of ultimate extinction, or the advocates of slavery will push it forward until it shall become lawful alike in all the states, old as well as new, north as well as south. So what does he say? That we have to do things. We have to immediately arrest its further spread, and now take the steps that, quote, put the public mind at rest that slavery is on the road to ultimate extinction. They say slavery is right and should be expanded. We say it's wrong and should be extended. He would always narrow the issue to what he needed to win the immediate battle before him. When he's charged with being for racial equality, he says he's only for equality of those rights that are included in the Declaration of Independence. Okay, so that's a narrow group: life, liberty, and the pursuit of happiness. What's not within life, liberty, and the pursuit of happiness? So that he understands where he wants to go and is able to do it. He's able to reconcept. What does he do about the fact that the supporters of slavery now have the Supreme Court of the United States on their side and the Constitution? But he used to say later that 7 years ago, he reimagines the founding document as not the Constitution, but the Declaration of Independence. And if the Constitution is imperfect, it is imperfect as judged by the Declaration of Independence. He holds up a copy in the debates with Judge Douglas and says that it says all men are created equal. If they wish to amend it to say that it applies only to white people, let them come and write it in the Declaration of Independence. And that in the right to eat the bread without leave of anybody else, which his own hands earned, and that he is my equal and the equal of Judge Douglas and every living man. Finally, I want you to take account of the fact that Lincoln was uniquely capable of moral growth. Yes, he was a very different person by 1864 than he had been earlier. He had presided over a war, and he personally was a link in the chain that made that war inevitable, and 750,000 people had died. 750,000 in a country 10% of our present size. And his son died, and this had a huge effect on him. The great African-American emancipationist, Frederick Douglass, said on meeting with Lincoln, which he did throughout the Civil War, that by 1864, he said he had never seen such moral depth in opposition to slavery as Lincoln was achieving. What he understood was that this became a moral crusade, that he had to save the Union, because without the Union, he would leave 3 million men, women, and children in forced labor and sexual slavery without any nation to ameliorate that. So finally, let me close and keep you all on your schedule and send you on your way by asking you, if you want to see great lawyering, read the second inaugural address. It's chiseled in stone, written in hand. He says, astonishingly, that he humanizes the enemy in a war that is still ongoing without giving up an inch of principle. And the war came, he says. 1/8 of the whole population were colored slaves in the southern part of it. All knew this was the cause of the war, and the war came. And he says both read the same Bible and pray to the same God, and each side invokes his aid against the other. But then he adds this powerful aside: it may seem strange that any man should dare to ask a just God's assistance in wringing their bread from the sweat of other men's faces. But let us judge not, that we not be judged. And finally, he utters the most powerful sentences of any American president, perhaps of any American public figure. He says that it's a curse on all of America. We have to, that this dreadful war with 750,000 dead must be God's will, that we have earned this retribution, we North and South. And he says, if God wills that this war continue until all of the wealth piled up by the bondsmen, by the slaves, 250 years of unrequited toil, when all of that is done, when all of that is sunk, and until every drop of blood drawn with the lash shall be paid with another drawn by the sword, the judgments of the Lord are true and righteous forever. We may have deserved this, all of us, an extraordinary moment. So I'll end these remarks where I began. Lincoln on the 16th of June, 1858, a financially insecure, failed politician with no administrative experience, one term in the House, a defeat for the Senate, a declining interest in his law practice, his wishes of accomplishment unfulfilled. That was Lincoln at the age of 50. At 56, he was dead. In between, he changed the world. Go forth and make Duke proud of you.